Today, we will discuss the significant risks and liabilities associated with the formation and operation of a business partnership, not to be confused with a limited liability company or corporation. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my law practice. Our firm website is www.cummings.law. Partnerships are a common business structure and are recognized in every state in the union. They are separate and distinct from limited liability companies and corporations, and therefore the word partnership should never be used interchangeably with corporation or limited liability company, as each is a legally distinct type of entity with differing legal and tax consequences. Partnerships are sometimes chosen by entrepreneurs due to the perceived simplicity and flexibility. However, this simplicity can often mask the complex legal implications inherent in such arrangements. A partnership is essentially an agreement between two or more parties to manage and operate a venture and share its profits. This structure can take many forms, such as a general partnership, a limited partnership, a limited liability partnership, and even a limited liability limited partnership, each with distinct legal characteristics and obligations. In a general partnership, all partners share equal responsibility for the management of the business and are jointly and severally personally liable for its debts. This means that each partner's personal assets are entirely at risk if the business incurs liabilities. Limited partnerships, on the other hand, include both general and limited partners. Limited partners typically invest capital in expectation of a return on that investment, but do not partake in management, and therefore their liability is restricted to the amount of their investment. Limited liability partnerships offer a degree of protection to all partners against personal liability, but the specifics can vary significantly depending upon the jurisdiction. It is crucial for individuals entering into partnerships to completely understand the legal structure they are choosing and the implications associated therewith. Misunderstandings about the nature of the partnership can lead to significant legal and financial consequences. Consulting with an experienced commercial law attorney and CPA is strongly advisable to navigate these complexities effectively. A well-drafted partnership agreement is indispensable for any partnership. This document serves as the foundation of the partnership, outlining the roles, responsibilities, rights, and obligations of each partner, as well as the procedures for decision-making, profit distribution, and importantly, dispute resolution. Without a comprehensive written agreement, partners may find themselves enmeshed in legal disputes that could have been easily avoided. One common misconception is that a verbal agreement or handshake is sufficient to provide for the clear delineation of rights and responsibilities in a partnership. In fact, an oral agreement or even an unspoken agreement can suffice to establish the partnership, but without a written agreement between the parties, this arrangement is ripe for expensive and time-consuming litigation. A written partnership agreement provides a clear record of the partner's intentions and is absolutely indispensable in resolving conflicts effectively and efficiently. Partnership agreements should be tailored to the specific needs and goals of the partners involved. This requires careful consideration of many factors, such as the duration of the partnership, the process for adding or removing a partner, and the procedures for dissolving the partnership. Engaging an attorney early in the process to draft and review the agreement can ensure that all critical elements are addressed and that the document complies with applicable law. One of the most significant legal risks associated with partnerships is the personal liability of the partners. As I mentioned earlier, in a general partnership, each partner is personally liable for the debts and obligations of the business, including those debts and obligations incurred without their knowledge by other partners. This means that creditors can pursue any partner for the full amount of any debt, that is, any debt associated with the partnership, regardless of that partner's level of involvement or acquiescence to that particular liability. To mitigate these risks, partners should consider early on implementing risk management strategies. This might include, among other things, obtaining appropriate insurance coverage, such as general liability insurance or professional liability insurance, to protect against potential future claims. Additionally, partners may explore restructuring the partnership into a limited liability partnership, or better yet, a limited liability company, or perhaps even incorporating the venture to further limit personal exposure. It is also critical for partners to maintain clear and accurate financial and company governance records and to comply with all regulatory requirements. Failure to do so can result in legal penalties and increased liability. Regular consultations with an attorney and CPA experienced in this area can help ensure that the partnership operates within legal boundaries and that potential risks are proactively managed. Partnerships are generally taxed as pass-through entities, meaning that the income, losses, revenue, and expenses of the business are passed through to the partners and reported on their individual income tax returns. This can offer certain tax advantages, such as avoiding the double taxation faced by some corporations. However, it also introduces complexities and nuances that necessitate careful planning and proactive management. Partners must understand that their tax obligations arise from the partnership, and that while the partnership is required to report information on Partnership Form 1065 to the Federal Internal Revenue Service, it is ultimately the responsibility of the partners to report and pay their share of that taxable income and to ensure that they comply with all applicable federal, state, and local tax laws. This necessarily includes the filing of appropriate tax returns, the making of estimated tax payments, and the keeping of detailed records of the partnership's income and expenses. Missteps in tax compliance can lead to significant penalties and interest. Given the intricacies of partnership taxation, it is advisable for partners to work closely with experienced professionals who can provide guidance on tax planning and compliance. This collaboration can help partners maximize tax benefits while maintaining the risk of audit and penalties. Partners should consider engaging an attorney and a CPA to assist in drafting dispute resolution clauses that reflect the specific practical and economic needs and preferences of the partnership and its partners. This proactive approach can help preserve business and personal relationships and ensure the continuity of the partnership to everyone's benefit. As I've said a few times now, partnerships offer a flexible and collaborative business structure, but they also carry with them substantial legal and economic risk. Understanding the complexities of partnership law and implementing appropriate risk management frameworks are indispensable for the success and longevity of the business. Given the potential for misunderstandings and disputes, it is crucial for partners to seek the guidance of experienced counsel. An attorney can provide invaluable assistance in navigating the legal and tax implications of partnerships, helping to ensure that the business operates smoothly and in compliance with all applicable law. Ultimately, the key to a successful partnership lies in careful planning, clear communication, and a steadfast commitment to addressing legal and financial challenges proactively. By investing in professional guidance, partners can protect their interests and lay a solid foundation for their business endeavors. Consulting with legal professionals to draft or review these documents can provide invaluable peace of mind and further ensure compliance with applicable law. By prioritizing legal preparedness, startups can focus on innovation and growth, confident that their foundation is secure. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier videos, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.